Arbitration is often projected as a private, efficient alternative to litigation, and it largely is. But that does not mean courts are completely out of the picture. In India, arbitration operates within a statutory framework, the Arbitration Conciliation Act of 1996, which defines not only the powers of the arbitral tribunals, but also carefully outlines when and how courts can intervene. We can break this intervention into three stages: pre arbitration, during the proceedings, and post award. Think of this as a roadmap, a guide to when, why, and how the Indian courts become relevant in your arbitral process. Let's start with the first phase, the pre arbitration intervention. If a party files a suit, even though there's an arbitration agreement in place, the courts would check whether a valid arbitration exists, and if it does, they would refer the matter back to arbitration. The idea is simple: to stop parties from sidestepping an arbitration clause just because they'd rather litigate. The second instance, appointment of arbitrator. If parties fail to appoint an arbitrator within the timelines agreed upon or prescribed, the courts may step in to appoint the arbitrator. This is a very typical early stage court involvement. The third instance, and perhaps the most important one, interim measures by the court under Section 9 of the Arbitration Act. This is when the courts may grant urgent protective measures like injunctions to provide immediate relief where there's no tribunal in place or where the tribunal's orders require judicial backing. So far as courts' intervention during arbitration proceedings is concerned, courts may step in when an arbitrator's mandate is terminated. They may be rendered incapable due to conflict, bias, resignation, or death, and a substitute is to be appointed. Or courts may be approached to assist the tribunal in recording evidence or summoning a witness. Another critical function where courts may be approached is for extension of time. When the award is not rendered within the stipulated 12 months, the courts may even reduce arbitrators' fees for delays attributable to the tribunal. And finally, the post-award judicial review and enforcement. The stage which sees courts' involvement extensively is when it is called upon for testing the validity of the arbitral award. There are limited and well-defined grounds for a challenge. For instance, lack of jurisdiction of the tribunal or procedural unfairness, patent illegality, or violation of public policy. Another section, Section 36, provides for enforcement of award. The court may treat the award as if it were a decree of a civil court and enable an award holder to execute the award through judicial mechanisms, like attachment of assets and sale of assets. The courts also have a very limited appellate scrutiny powers. They can entertain appeals against certain orders, for example, orders against granting or refusing interim reliefs, orders setting aside or refusing to set aside awards. The courts have an even more restricted role so far as international arbitrations are concerned, which is limited to referral and enforcement. Courts may ensure compliance while ensuring that the award was not passed with lack of due process, in excess of jurisdiction, or in violation of public policy. So the bottom line is that while arbitration is designed to minimize court involvement, it certainly doesn't eliminate it. Something to keep in mind when you're strategizing your next dispute.